All right. Well, what I'd like is if there are any post new evidence code cases with similar facts to ours. So I'd rather have something in writing if y'all don't mind.
I will, but there's a ton of
All right.
cases.
Well, you don't have to give me every one. Just
So the state is wrong.
okay. I don't want to argue it right now. I want a written response. All right. Appreciate it.
And we are back, Everybody go ahead and hit that like button. Today we're going to bring you a very interesting video on the heels of what happened yesterday. Now, as a quick flashback, yesterday Detective Dennis of the infamous pair, Dennis and Gaither, the two gang cops who set out to take down the YSL record label, Detective Dennis was permanently banned, barred, and kicked out of and just booted from the YSL trial for misconduct because he talked about Yak Gotti's criminal past when he, as a retired investigator, retired detective, should have known better. Now, Whitaker, she was not having it. She kicked him out. But D.A. Hilton, who was examining Dennis at the time, she really couldn't. She saved the mistrial, right? So there was a mistrial motion on the floor at the moment, and she saved that. But she lost her witness. She lost all the exhibits. She lost his future participation in the trial. So after this, the state has now filed a motion after Detective Dennis was absolutely kicked out and booted from the YSL trial. The state has filed a motion that we are going to review right now. Now, I'm going to tell y'all something. I'm going to tell you what to look out for. And I'm going to tell you that you're not going to hear this. I want your ears to perk up. I want you to pay full attention. And I want you to see the gaping deficit, the gaping hole in this motion. The gaping hole, the gaping deficit in this motion is it does not address the defense's argument. This motion should present a clear path forward where the defense can be at least somewhat satisfied, where the state can be at least somewhat satisfied, and where the judge can save face and be somewhat satisfied. You're not going to hear that. What you're going to hear is the state tell the judge that she's wrong, that they, while the Detective Dennis did do something wrong, they're going to admit that, but they're going to say that they should get their way, the state should get its way. They're going to tell the judge she's wrong, and they're not going to present any kind of clear path forward where the defense's reasonable objection can be handled. So I'm going to play the clips from yesterday for you so you can see what I'm talking about. And as you listen to me read this, notice that there is absolutely no path forward where all parties could be at least somewhat taken care of. Okay, so I'm going to read. State's motion to reconsider oral order striking witnesses' testimony and related exhibits. Comes now the state of Georgia and respectfully moves this honorable court to reconsider its October 17th, 2024 oral order striking the October 17th, 2024 testimony of witness retired investigator T. Dennis and related exhibits and precluding his future testimony as a sanction for an inadvertent, non-responsive answer during his testimony. In support thereof, the state shows the following. Background. During Investigator Dennis's testimony, Investigator Dennis referred to actions Defendant Diamante Kendrick performed immediately after his release from custody. Defendant Kendrick moved for mistrial, which this court appropriately denied. As a sanction for this event, however, the court struck the entirety of Investigator Dennis's October 17th testimony, precluding him from testifying in the future, and struck from evidence exhibits which Investigator Dennis had authenticated on October 17th. 2. The scope of the state's claim. It is appropriate for the court to strike a witness's answer from the jury's consideration when it contains information the court finds the jury should not have heard and should not consider. The state does not contest that part of the court's ruling. The state submits, however, that the order striking the entirety of the witness's October 17th testimony, precluding the witness from testifying in the future, and excluding exhibits which had been admitted through that witness on October 17th was improper, as an exclusion of evidence which the law does not permit. The state thus respectfully moves the court to reverse those portions of the court's oral order. Analysis. Evidence exclusion is an extreme sanction and not one favored in the law. This is so strongly a part of Georgia law that even the most well-established privileges are narrowly constructed as, quote, the ascertainment of as many facts as possible leads to the truth, the discovery of which is the object of all legal investigation, end quote. OCGA 244402, or Rule 402, provides in relevant part that all relevant evidence shall be admissible except as limited by constitutional requirements or as otherwise provided by law or by other rule, as prescribed pursuant to constitutional or statutory authority applicable in the court in which the matter is pending. That is, Rule 402 forbids a court from excluding evidence unless constitutional or statutory authority authorizes that exclusion. Here, no constitutional or statutory authority authorizes the exclusion of the non-offending portions of Investigator Dennis's October 17th testimony, of his future testimony, or the related exhibits. All right, y'all. This is all we need, y'all. What I want to do is summarize the rest of this because I'm sure you all don't want to hear every word of this legal argument. What I'm going to tell you here is that the rest of this says, Judge Whitaker, you do not have the authority to exclude this evidence. So they have made themselves, the state has made itself an opponent to Judge Whitaker and her order. What they have not done here is they have not given Whitaker any way of maintaining her order, satisfying the defense's claim that they need to be able to cross-examine Detective Dennis or Investigator Dennis. They haven't done that. So basically, their way of going about this is to say, Judge Whitaker, you overstepped your authority. You are wrong. And we're asking you within your authority to correct your wrong. I would imagine that Judge Whitaker is not going to side with the state because, again, they are not only telling her that she's wrong, but this entire write-up does not even attempt to address the main point or one of the main points of contention that the defense is going to have, which is that they do not get to cross-examine Detective Dennis. So I think this motion is going to fail. I would like to hear from you all in the comments. Like, comment, subscribe, and let me know what you think will become of this motion to reconsider. For those of you who did not catch it yesterday, I'm going to replay everything that happened yesterday so you can see what all of the kerfuffle is about. If you've already watched this, well, you can watch it again if you like. If not, everybody don't forget to like, comment, and subscribe, and thank y'all for watching.
Now, looking at Stacey Exhibit 1 TT, why was
Your Honor, this one you cannot fix. This is bad character evidence that came in. The state should have prepared their witness. I move for a mistrial. This absolutely cannot be unheard by the jury. It was heard clear as day in his deep, sonorous voice They have heard it. They have absorbed it. It cannot be fixed. 404A, Your Honor.
Here, whatever response the state might be able to make on that.
Your Honor, that was not the state's intention.
I'm sure it wasn't.
Your Honor, that response didn't even come across my mind that would even have come out of our witness's mouth, Your Honor. The state's intention was to solely talk about the vehicle that he was standing on and the fact that he was standing on that vehicle. If you can just give us an opportunity just to look at some case law just to see if we can.
Your Honor, I'm sorry. How many times has this man testified in a trial? How long has he been I know he's a retired investigator. How long has he been an investigator? He knows he is not supposed to say that, Your Honor.
I would find it surprising if he isn't aware that that's not supposed to come out. I do not believe that the state intended to elicit that, and I think that you actually yourself acknowledged up here at the bench that you don't believe that was the state's intention.
I do not believe it was their intention.
Nonetheless, it happened. I'm going to give y'all about 15 minutes or so to find whatever you might be able to find.
Thank you, Your Honor.
All right.
Thank you.
What is the state?
Yes, Your Honor. The state will ask that you deny defendant's motion for a mistrial. The state would like to cite the court to Swims v. State, which is 307 Georgia, 651, a 2020 case, Your Honor. In that case, which was the defendant's only enumeration of error, and I'm in Division 2 of that opinion, Your Honor, Swims contends that the trial court erred in denying his motion for mistrial after his character was improperly placed into evidence during Chelsea Owens' testimony. When the state asked Owens if Swims offered any reasoning for why he wanted to escape, Owens responded, and this is what the witness said in that case, I asked Swims, why would he do that? I said, why would you want to do that? He told me because they did not honor his fast and speedy trial. He was looking at getting off on a technicality because they didn't honor that. He didn't have that for his defense. He said he was doing time. He had a lot of time in West Virginia that he wasn't never going to get out. In that case, Swims' trial counsel immediately asked to approach the bench and moved for a mistrial. The trial court judge overruled Swims' objection and denied his motion. The state resumed its direct examination of Owens, who then testified that Swims provided another possible motivation for attempting an escape, that Swims had murdered Clemson. I asked him, did y'all kill that child? And he told me, why do you want out of here so bad? So that was how the testimony continued. I'm going to skip down. A trial court's denial of a motion for mistrial based on the improper admission of bad character evidence is reviewed for abuse of discretion by examining factors and circumstances, including the nature of the statement.
Slow down reading, please.
Sorry. The other evidence in the case and the action taken by the court and counsel concerning the impropriety. And they cite Smith v. State, 302 Georgia 699. A passing reference to a defendant's incarceration does not place his character in evidence. And they cite Lewis v. State, 287 Georgia 210 at Penn site 212. Furthermore, Owens' passing reference to Swims' incarceration in West Virginia for an unstated crime was an unexpected answer to the question asked by the prosecutor, who was attempting to establish that Clemson's murder was the reason Swims wanted out of jail so bad. And they see Walker v. State, 282 Georgia 703. A non-responsive answer that impacts negatively on a defendant's character does not improperly place his character in issue. After Swims' mistrial was denied, the state did not inquire further into Swims' crimes in West Virginia beyond a single confirmation that his incarceration there also served as a motive for escape. Your Honor, given what occurred in this case, Your Honor, the state's intention when I asked the question, what was the significance of that picture, the state's intention was solely to talk about the fact that Mr. Kendrick was standing on that car being that of Rayshon Bennett. His mother had identified that car yesterday during her testimony, Your Honor. So it was an inadvertent response which was non-responsive to the state's answer, Your Honor. And given that is what occurred, Your Honor, the state would ask that you deny their motion. Furthermore, Your Honor, other factors that you look at in order to determine whether or not a mistrial should be granted is the nature of the statement, other evidence in the case, the actions taken by the actions taken by the court.
The what?
The actions taken by the court. Was the reference isolated and brief, and whether the jury's exposure was repeated and extensive, and was it inadvertent? Additionally, Your Honor, within the indictments, Your Honor, we did charge Mr. Kendrick with, as one of the overt acts in this indictment, which is Act 58, and he's also charged in this indictment in count 63 of this indictment, Your Honor, possession of a firearm by a convicted felon, previously convicted of a felony involving the use or possession of a firearm. Your Honor, so for the purposes of having to prove that count of the indictment, we will have to enter Mr. Kendrick's certified copy of his conviction, of course, with a limiting instruction that only be used against him, Your Honor. So the fact that came out during that testimony would not be substantially more prejudicial, Your Honor, given that, one, the jury has heard this indictment, and as well as this evidence will come out, at least that he was convicted, because we have to prove that portion of the indictment, Your Honor. So we would ask that the court deny his motion.
All right.
And we have instructed our witness, pass that as well.
Ms. Weinstein.
Thank you, Your Honor. In the Swims case cited by the state, correct me if I'm wrong, but I do not believe that was a seasoned officer that testified about the bad character. Is that correct?
I don't know if it was a seasoned officer.
Yeah, no, I looked. It's not.
It's
It was
an
a fellow
inmate, right? And I think there's a distinction between a fellow inmate and an officer with decades of experience. And it's not just I that think that. I mean, I think if you go back and look at Posey v. State, which you may have already looked at, 152, Georgia Appeals 216, there you have a case where a seasoned officer testified about bad character of a defendant. The court in that case called for, there should have been a mistrial. It says that when it's impossible for the trial court by corrective instruction to rectify the harm done by improper testimony, a mistrial must be granted. And again, the issue here is you have a seasoned officer, someone with years of experience testifying. And in Posey, there's really very instructive language from our courts, where they say, we reiterate here, I'm sorry, I'm talking too fast.
And too loudly.
Yeah, you know what? I'm going to tone it down. We reiterate here what we said in Boyd. It may well be argued that peace officers are not always well acquainted with our rules of evidence, and that statements such as the one here are merely inadvertent. I'm going to stop the quote for a second to say something, which is, again, here we have a peace officer, here we have an investigator who is well seasoned. The quote continues, but if we refuse to reverse this judgment, then we provide no incentive to district attorneys and solicitors to counsel their witnesses, especially law enforcement officers, to avoid extraneous and inadmissible outbursts. It is high time that this court go on record as opposing without reservation such conduct by law enforcement officers. Posey is exactly on point. Posey calls for a mistrial. This officer should have known better. The state should have properly prepared the witness to not issue, to not blurt out, to not state so clearly that my client was just getting out of prison. It cannot be corrected, Your Honor.
All right. Any last words by the state Well, actually, never mind. It's the defense's motion, so y'all don't get any last words. All right. I think I am finding that this was not intentionally elicited on the part of the state. However, I also am finding that this witness as a law enforcement officer should have known better than to make any mention of it. It is, however, significant that one of the charges against Mr. Kendrick in this indictment is that he is a convicted felon. Were it not for that, I would grant the mistrial motion. But given that this jury already knows that he's been convicted and is a convicted felon anyway, even without this testimony, I don't think that a mistrial is warranted. I am, however, going to give a curative instruction, and as a sanction for this having occurred, that's the end of the testimony from this witness. There's going to be no more testimony from him. So he's done. All right. What I am proposing to say as an instruction is Defendant Kendrick's prior criminal history has no relevance to this case except as to count 63 and should not have been mentioned. Further, this witness, as a former law enforcement officer, should have known better than to make any mention of it. Likewise, Mr. Kendrick's criminal history should not be considered in connection with any of these other defendants or any of the charges against them in this case.
Your Honor?
Yes, sir.
I would also then, because we didn't have the opportunity to cross-examine, so it would be a confrontation clause. It would be reversible error. So I'm moving.
Let me ask you this. Have y'all cross-examined him the
Yes.
2 times before?
Yes.
All right, so we're going to strike everything he said today.
And
all right.
the notes, just like you did before, all the notes, they have to go back, give them to the court if you don't mind, put them under seal, or, and that's what I remember you doing, but whatever you did with them. And if they can't follow that instruction, please alert your honorable court if you don't mind.
You're right. Can we just ask that we could just stop our testimony and give them an opportunity to cross-examine him?
No, I guess you can ask, and the answer is no.
But I don't
The
think
answer
that,
is no. You can make a record.
Yes, Your Honor. Your Honor, I don't believe that my question was broad.
It's not your fault.
And I understand that, but Your Honor, the testimony that was given today, this was a one-time infraction, Your Honor. And we would just ask, we can understand that if his testimony, if the state no longer can question him, we would ask that all of his testimony from today is not stricken because of one mistake. Like this was one mistake that he made, Your Honor. We would stop our questioning of him, allow the defense to cross him on what has come out now, but all of the information that he's provided this far, he has been careful. He has not said anything today that was even remotely close to what happened here right now. I believe it was a mistake on his part. Maybe as a state, I should have instructed clearer, and I will take that responsibility, Your Honor. But given that this was one moment in time, the state is going to ask that we will stop questioning. If that's the sanction that the state has to stop questioning him, Your Honor, we will take that sanction and ask that the defense be allowed to cross him and that we be not allowed to direct him, and that's fine, but not that his entire testimony from today be struck, Your Honor, given that that was one mistake that he made very short in time, Your Honor.
All right,
we would
understood.
Just ask that.
Do I need to
ruling
respond to that,
stands.
Your Honor?
You don't
Okay.
need to.
Thank you.
Yes.
I did not mention it, but also all the exhibits admitted through this gentleman need to be taken back under seal as well and disregarded by the jury, please.
Do you have another witness available?
We're
Okay.
trying to figure that out.
All right, go ahead and get them lined up.
Excuse me, Your Honor. I have one question. Is retired investigator Dennis going to return to the stand at some point? I'm not sure if the state had planned on that or not, or if your sanction would bar that as well.
Oh, no, he won't be returning.
Thank you, Your Honor. I just wanted that clarified.
Unless you'd like for me to have him come back and admonish him. But I'm not going to do it in front of the jury because I don't think we need to highlight it further. Okay. I kind of would like to tell him he should have known better, though. Y'all can just relay that. Okay.
Excuse me, Your Honor, and I'd like to renew my motion for mistrial prior to the next question.
All right. It is denied.
Thank you.
Okay. Do you have another witness you can put up now, or do I need to give y'all a few minutes? Okay. Why is the possession of a firearm by a convicted felon, why is that already in before the jury? That wasn't bifurcated?
It was not bifurcated, Your Honor.
Did nobody ask that it be bifurcated?
This has been a long trial, and I know you're not asking about my client's charges, but my recollection is I asked for my client's charges to be bifurcated,
I think we did.
and it was denied. Is my recollection, and so.
It might be, I'm going to check, you overact as well, and that's why I'm going to check. So it's an overact, so like a felony murder with the underlying.
Okay, what is the overt act? That they're convicted felons? That would be weird. I mean, there has to be some reason, but, oh, that,
187,
That's why it wasn't exact.
okay, well,
189.
The 187 is just possession of fire.
189. Okay, that explains it. Okay, well then I guess my instruction will say as to count 63 and alleged overt act 189. Okay. Where'd my instruction go? Okay, thank you. Okay, which actually then has to change my instruction as to the rest of them too. In order to be correct, my instruction would be his prior criminal history shouldn't be considered in connection with any of the other defendants except to the extent the jury finds it relevant to overt act 189, which y'all may not want said at all. You may want me to just not say anything at all about it. So what's the defense preference, everybody other than Mr. Kendrick? You know what I'm asking? Yes. So I was going to say that his prior criminal history shouldn't be considered in connection with any of the other defendants or any of the charges against them, but that's not actually true if it's an overt act. And so do you want me to just not say anything at all about the other defendants, or say it shouldn't be considered against any of them except to the extent it might be relevant to their determination of overt act 189?
But, Your Honor, I thought we discussed this. The overt act is coming in as an admission by Mr. Kendrick, which violates our confrontation clause right. That's the instruction the state was supposed to give to you when they were talking about the same thing,
Right,
overt
the
act.
conviction itself.
Right.
In that.
So that would insulate us, not Mr. Kendrick, of that overt act. And that's the instruction I tried to do, and I cannot formulate it, and you asked the state to do it. And it goes
Yeah,
to Mr.
I
Ryan.
mean, I'd love for both of you to at least come up with your best effort on it. So
it does not apply to Mr. Matthews, Miss
any of the rest
Williams,
of them,
right.
basically. But so
Instruction you've been waiting on.
I know. But I think, yeah.
If I may just continue speaking, that's why I believe that Mr. Ryan's jury verdict, Mr. Kendrick's conviction, Mr. Stillwell's conviction, there might be one more, the guilty pleas, Mr. Winfrey, but I've discussed that, should all be kept out of this trial. Because somebody like me, Mr. Williams is not a convicted felon. He can't cross any of these people unless they testify. And I don't believe that a limiting instruction will be fashioned. That's my belief.
And y'all are planning to prove those as to the defendant who's convicted with their convictions, but are you doing anything beyond that?
No, Your Honor, and I think that was what Ms. Love was working on as far as crafting instruction, that it only goes against the defendant whose conviction, it only goes against that defendant, not the other.
Even as an overt act, even in consideration of RICO?
And I think that is where, as I say, we've been trying to word it, and Mr. Steele and I have had brief conversation figuring out the best wording.
But do you agree that they can't, even if they find that overt act with regard to Mr. Kendrick or Mr. Stillwell, it normally would be that, you don't, if you find that any of the co-conspirators committed an overt act, which then they would have found that as to these people if they believe the conviction, then all you need to find with regard to the rest of the co-conspirators is the rest of what's required for the RICO violation, not a separate overt act. You know what I'm saying? And so how is it not in some way considered? It's not necessarily considered against them, but it checks a box that has to be checked with regard to each defendant that somebody committed an overt act. Okay, here's somebody who committed an overt act. And so it checks that box for what's required for RICO.
Can I ask, Your Honor, for this purpose for right now, can we do the curative instruction that they disregard what you said?
Yeah, but I mean, what do I say? Disregard it with regard to any of these other defendants or any of the charges against them? And then y'all just are going to have to prove something else, or what? Because I don't want to give them the wrong instruction. I mean, and it may be that it does have to be some other overt act with regard. I don't see how it can't, how you get around confrontation clause. You know?
Yes, Your Honor. I guess my thought is if you're striking, for purposes of today, if you're striking his entire testimony, then everything he has said is.
I know, but I'm trying
Yes.
to tell the jurors, Mr. Kendrick's criminal history is not relevant except with regard to count 63 and overt act is it 189?
Yes, Your Honor.
But really, I mean, is that,
Can we,
or you can just strike overt act 189 out of the indictment? That would be easier.
And that was our position, because there's no way, respectfully, that a highly intelligent juror like we have is going to be able to follow this gymnastic.
and I guess our thought is, since you're striking his entire testimony now, can we deal with the felony portion of the instruction later?
I mean, I'd love to, except for the fact that now's the time to do it. I'm taking their notes away, and I'm saying to them, what you heard about him having just gotten out of prison, you need to disregard except for some very limited reasons.
But since we have not put his conviction in, if you just tell him to disregard everything at this point, there's no evidence before them about him being in prison right now. So my point is, if you just tell them disregard everything that they heard, there is no other evidence for them to consider right now.
So then I would say his prior criminal history has no relevance to this case. And yes, it will ultimately have relevance to count 63. And I know we don't have what the conviction is or why he was in prison yet, and they're being told to disregard it anyway. But I mean, if y'all can come up with some better wording, great. I mean, I can just say this witness, as a former law enforcement officer, should have known better than to make any mention of Mr. Kendrick having been in prison, but.
No, I don't think that part is necessary, Your Honor. Given that I do think it was a mistake. Can you read your instruction again?
Yeah.
Thank you.
Defendant Kendrick's prior criminal history has no relevance to this case except as to count 63 and overt act 189 and should not have been mentioned by this witness. Further, this witness, as a former law enforcement officer, should have known better than to make any mention of it. Likewise, Mr. Kendrick's prior criminal history should not be considered in connection with any of these other defendants or any of the charges against them in this case. I'm going to strike the testimony of the witness today, disregard the testimony exhibits, I'll collect your notes, blah, blah, blah. I mean, I guess that can just do for now, and we can get into the nitty-gritty of it with regard to RICO later. I just think if we can't come up with something better in the next couple of minutes. That's what I'm going to go with. All right, anything?
Your Honor, I think the limiting instruction should be similar. I'm sorry. My apologies. Your Honor, let's see. Can you hear me now?
I can hear you anyway. Can y'all hear him? Okay.
So the state's recommendation would be the similar limiting instruction that you've been giving as it relates to the other evidence or that you've given previously as it relates to the other evidence, for example, that came in today during the prior testimony about Mr. Jackson. Pretty much the same instruction with obviously you're changing the fact that there will be certain, there will be evidence related to certain defendants that they have prior convictions. You're not to attribute those convictions to any other defendant other than the ones in which it's related to in the counts of the indictment. Something of that nature.
Okay. All right. So our issue that we're struggling with is that it's an overt act in the RICO count. And it's apparently going to be proven ultimately by his conviction, which is, of course, testimonial. And how can that be considered against any other defendant? And that hadn't been sorted out yet. I'm just going to say should not be considered in connection with any of these other defendants in this case. All right, that's what I'm going to say. So let's get the jury out. Yes. Do you need to approach if I don't have the jury here yet? All right, ladies and gentlemen. Gone. I am sorry for the delay. I need to give y'all an instruction. Defendant Kendrick's prior criminal history has no relevance to this case except as to count 63 in Overt Act 189, and it should not have been mentioned by retired investigator Dennis. And further, Investigator Dennis, as a former law enforcement officer, should have known better than to make any mention of it. Likewise, Mr. Kendrick's prior criminal history should not be considered in connection with any of the other defendants in this case. I'm going to strike the testimony of Investigator Dennis that was given today. You're to disregard today's testimony and the exhibits admitted through Investigator Dennis today in their entirety. We'll collect your notes from today and shred them. And if there's anybody that is not going to be able to follow those instructions, please let the court know that now by raising your hand. Everybody good? Okay. Yes. And he's all we've heard today so far. Anyway, we are going to hear some further testimony from other witnesses. So just, I know if some of y'all are trying to conserve paper, so we'll do the same thing we did before if anybody's written on both sides, but otherwise, is that what your question was going to be? Okay. All right. So just flip to a new page now, and we've got a couple more hours, and we'll just collect them at the end of the day. All right. Okay. Call your next witness.